Brisman, and I'm here to talk to you today about the legal. I own a law firm and a surrogacy agency, and I have 3 kids from gestational surrogacy. So the first thing really that I should make a distinction about is that I'm going to talk mostly about gestational surrogacy. Traditional surrogacy, as John said, is not as popular, but just to go over the legal a little bit, in almost every state in the United States, when you use a traditional surrogate, meaning the surrogate is both the biological mom, it's her egg, and her womb, she's going to have her rights terminated after birth. Meaning there's going to be a period of time, and whether that period of time is 72 hours or 30 days, there's going to be a period of time in which she could fight for custodial rights of the child. So for many reasons, even though it is still unusual for a traditional surrogate who's screened properly to change her mind, it is legally riskier and psychologically riskier. So most people now are doing gestational surrogacy. And gestational surrogacy is much more accepted legally across the United States. Unfortunately, in New York, it is not really as accepted as in most of the other states. So I wanted to start by just basically telling you a little bit about New York law. In New York, it's still the case that you cannot compensate a gestational surrogate. So basically what that means is that you can live in New York, you could live in Europe, it doesn't really matter, but your surrogate can't reside and give birth in the state if she's compensated. Because if you have a compensated surrogate in the state, you're violating New York law. So you can have a non-compensated surrogate in the state of New York, but there can be no pre-existing or binding agreement for her to relinquish the child. So there are a couple of options you will have if you have a friend or a family member in New York. Just about 8 weeks ago, our firm was successful in overturning the statute in New York in one aspect only. That means that right now, it used to be that if you used a surrogate in New York and she was uncompensated, you would have to do an adoption. Now, it is possible to get birth orders in New York, meaning that it is not 100% that you're going to have to do an adoption if you use a surrogate in New York, but she still can't be compensated and it's still going to be post-birth. So most of you who are using surrogates that are not relatives, the majority of people are using paid surrogates through one of the agencies or somebody that they find, are going to find themselves finding a surrogate outside the state of New York. And that's going to be very important. You're going to want to know the state law. So you're going to want to make sure whatever agency you go to, or if you find a person on your own, that you know the states that you're going to be looking for your surrogate in. Actually, on Friday in our office, we just had somebody come in with a pregnant surrogate who lives in New Jersey. So in New Jersey, the person can't be compensated. So what am I going to do with her now? I'm having to pray that she makes it over the border because we didn't find them or do anything in this arrangement, and now they're coming to us halfway through. We don't know what to do. We have a pregnant surrogate who's being paid in New Jersey. So you want to make sure these things are investigated in advance. And on the East Coast, there are a lot of good states, but there are differences about the states. So for instance, if you have a surrogate in the state of Massachusetts, you can have both your names on the birth certificate as the parents if you're 2 gay men, but not if you're not married. Because if you're not married, there's a woman who John and I love, who's in the State Department, who basically her job in life is really to make everyone else's life difficult. And if she sees on the petition that you're not married, whether you're heterosexual or you're a same-sex couple, she's not going to allow your petition to go through. So that's not going to be the case, let's say, in other states, like in California, where if you're 2 men, you'll go on the birth certificate even if you're not married, just as long as you're doing it together. So you're going to really want to know the state laws and how the birth certificate is going to work. Now, if you just have 1 man on the birth certificate, that doesn't mean that there's a woman on the birth certificate. It could be just you get a birth certificate that just has the genetic father. You bring that baby back to New York, and then as a lawyer, we'll do a second parent adoption for you, which if you're residents of the United States is quite easy. It's just a paperwork thing. And people don't like to do it, but it is not really hard to do. It's just a bunch of paperwork we submit to the court, and the court appearance actually with me in the state of New York is probably less than 5 minutes in order to actually have your birth certificate amended. So people are afraid of the word adoption, but when one person is biologically related, it's actually not that hard. So that's always an option if you get a surrogate in a state where it doesn't allow 2 men. So basically, you have to think about, as a couple, what you want, and then you can look at the different state laws. But there are certain states like Washington Washington, D.C., Michigan, that you want to stay away from because you know those states are not going to be good if you have a compensated carrier. There are states that are going to be better, states that have statutes in place, and states that don't, so that's going to be something to look at. Once you have your carrier, selected and screened, there's also other legal things that we're going to do. Now we're going to do a contract. I cannot tell you the most important issue in the contract that I spend the most time on is abortion and reduction. It is a completely unenforceable specific term of the contract, meaning that if you have in your contract that your surrogate will have an abortion if your baby has Downs, and she changes her mind and no longer wants to have an abortion for Down syndrome while she's pregnant, no court is going to make her undergo that abortion. That doesn't mean you can't have some sort of penalty monetarily. You can stop paying her. You can figure out who's going to have custody of the baby, but you're not going to be able to make her abort your genetic child against her wishes. So this is hugely important to talk about in the beginning. We can put it in the contract, but this performance, the damages will be monetary. There won't be specific performance. So really, you want to make sure that your social workers, and I'm sure Kim's going to talk about that more, that you're on the same page about that. That you want to make sure that if you want your carrier to carry triplets, if those 2 embryos you put in split into triplets, that she's okay with that. And that if you want her to carry twins, that she's okay with that. If you want her to have an abortion, at what period of time and an amnio. Those are the most important things about the contract. There will also be other things. You want to make sure that there's an escrow account in place. You want to make sure that the monetary is all spelled out. The worst thing that I always tell people is, if I have to look at the contract after you're pregnant to figure out what's going on, that's not good. The contract is supposed to be a roadmap of how things are going to play. And if I'm constantly going back to the contract, that means that there are relationship issues. And the whole purpose of the contract is to lay it out on the table so that there are not relationship issues. I always think it's important as well to have a contract, even if it's your sister or a family member. These are the most likely to wind up in litigation if you do surrogacy. Whenever you use a sister or family member, your sister is not going to change. She's going to be the same person that she was. So, for instance, I always think in my family, if I get really annoyed with my brother, I just hang up and call him 3 days later because I just can't take it. But you know what? If your sister's carrying your baby, you no longer have permission to hang up on her because she's moody. So there is a different dynamic. The things about her that you didn't like are just going to be amplified when she's pregnant, or your sister-in-law, your friend. So you have to make sure you're going to be able to tolerate that. And counseling is very important, more important than the legal one as a family member, because it is the hardest. So those contractual issues, essential, family member, friend, paid surrogate, attorney on both sides. If your family member, your surrogate, wants to back out, if I'm representing a surrogate and she wants to back out, I always make myself the bad guy. I don't really mind if you don't like me, but I don't want you to hate your sister. So I think that's very important. Ron is telling me I have 2 minutes left, and he gave me a list of 22 things that he wanted me to talk about, and I'm on number 2. So if you have questions afterwards, I'm sure all of us will be here. But just a little bit about to talk about getting your name on the birth certificate and insurance. Usually we try to have a plan for how we're going to file your court order before she gets pregnant. And also from a legal perspective, we want to look at the insurance. One of the great things is if you live in New Jersey, there's a regulation that I helped write that if you have a medical reason and you use a surrogate, your surrogate can be covered under your plan. That wipes out the need for any kind of other insurance, Lloyd's or anything. And so there are we want to look at the benefits that are available. We have argued it for same-sex couples as well, and every once in a while we do get it through. So it's important to analyze the insurance at the beginning. It really can help your overall costs, and to be very cautious with it because you want to make sure that you have as many backups. We always recommend getting a Lloyd's backup policy in case you have a problem. So that's really about an eighth of the legal process. So